Good afternoon, classmates. I hope everyone is safe. I'm John Go, and my topic for today is about obligations with penal clause, which is under Article 1226 up to 1230 of the new Civil Code. Under this topic, I will discuss to you first is penalties versus liquidated damages. Second, escalation clause versus acceleration clause. Third, legal rates. Fourth, reduction of conventional penalties. For the first topic, we will tackle penalty versus liquidated damages. Let's distinguish the both. Well, it has been held that there are no difference between a penalty and liquidated damages, so far as the legal results are concerned. Whatever difference exists between them is just a matter of language. They are treated the same legally. In either case, the party to whom payment is to be made is entitled to recover the sum stipulated without the necessity of proving damages. One of the primary purposes in fixing a penalty or in liquidating damages is to avoid such necessity. Liquidated damages was defined in the case of Titan Construction Corporation versus Unifield Enterprises, where a stipulation on liquidated damages is a penalty clause where the obligor assumes a greater liability in case of breach of an obligation. In contrast, according to the Code Commission, liquidated damages are different from penalty in that while the former are agreed damages, the latter is more of a punishment. For the second topic, which is escalation clause versus acceleration clause. So, what is an escalation clause? The Supreme Court defined escalation clause in the case of New Sampaguita Builders Construction versus Philippine National Bank. It was provided that escalation clauses are valid stipulations in commercial contract to maintain fiscal stability and to retain the value of money in loan term contracts. Escalation clauses refer to stipulations allowing an increase in the interest rate agreed upon by the contracting parties. Of course, there is an exception into it. The Supreme Court held that an escalation clause which grants the creditor an unbridled right to adjust the interest independently and upwardly, completely depriving the debtor of the right to assent to an important modification in the agreement is void. A stipulation of such nature violates the principle of mutuality of contracts. The validity of escalation clause does not give the creditor the unbridled right to unilaterally adjust interest rates. The adjustment should have still be subjected to the mutual agreement of the contracting parties. In light of the absence of consent on the part of the debtor to the modifications in the interest rate, the adjusted rates cannot bind them in a loan agreement. Let's take the case of Polotan versus Court of Appeals. Petitioner Polotan, a cardholder, assailed the trial and appellate courts in ruling for the validity of the escalation clause in the cardholder's agreement. Petitioner contends that the interest rate was unilaterally imposed and based on the standards and rates formulated solely by the respondent credit card company. The Supreme Court held in the contractual provision in question, which states that if there occurs any change in the prevailing market rates, the new interest rate shall be guiding rate in computing the interest due on the outstanding obligation without need of serving notice to the cardholder other than the required posting on the monthly statement served to the cardholder. The Supreme Court held that this cannot be considered as an escalation clause for the reason that if neither states an increase nor a decrease in interest rate, the clause simply states that the interest rate should be based on the prevailing market. So what is an acceleration clause? Acceleration clause is a clause which would make an installment due upon default in one installment. Default in the payment of one installment does not mean default in the whole amount. If there is an acceleration clause on the agreement, all that happens will be that the whole amount becomes due, and demand is still needed to put the debtor in default. Let's jump to the next topic, which is legal rate. So what is a legal rate? A legal rate is presumed by the law to have been agreed upon if the loan mentions interest but no rate was stipulated. Under the usury law, they are legal rate is at 12% per annum. The legal rate of 12% from default until fully paid if the transaction is a loan or forbearance of money, goods, or credits, or the judgment involves a loan or forbearance of money, goods, or credits as prescribed by the central bank. Otherwise, in the instances of indemnity for damages occasioned by an injury to person, loss of property, it is only 6% as provided in Article 2209 of the Civil Code. If the loan is secured in whole or in part by a mortgage upon real estate with a torrens title or by any agreement conveying such real estate or an interest therein, the maximum rate set is 12% per annum. If the loan is not secured, then it is 40% per annum. Lastly, for my final topic, reduction of conventional penalties. Article 1229 of the new Civil Code provides that the judge shall equitably reduce the penalty when the principal obligation has been partly or irregularly complied with by the debtor. Even if there is no performance, the penalty may also be reduced by the courts if it is iniquitous or unconscionable. So let us define what is iniquitous. Iniquitous means grossly unfair or morally wrong. And unconscionable in layman's term means unreasonable. Let's take a look on the case of RGM Industries versus United Pacific. RGM Industries has taken a loan from United Pacific. RGM eventually defaulted. Upon restructuring the loan, United Pacific imposed an interest rate of 32% and an attorney's fee of 25%. The RTC ruled in favor of United Pacific, which was the creditor. The Court of Appeals affirmed the RTC's judgment but modified the interest rates and penalty charges imposed. The Court of Appeals held that the interest rates levied by the respondent were excessive and unconscionable, hence must be reduced to 12% per annum, and the attorney's fees were reduced from 25% to 10% of the outstanding obligation. The Supreme Court held that they affirmed the Court of Appeals decision, providing that stipulated interest rates are illegal if they are unconscionable and courts are not allowed to temper interest rates when necessary. In exercising this vested power to determine what is iniquitous and unconscionable, the court must consider the circumstances of each case, which may be innocuous and unconscionable in one case and may be different from another. And lastly, under Article 1230 of the new Civil Code, which provides the nullity of the penal clause does not carry it that principal obligation. The nullity of the principal carries with it the penal clause. To simply state it, if one if only the penal clause is void, remains valid and demandable. The penal clause is just disregarded. The injured party may recover indemnity for damages in case of non-performance of the obligation, as if no penalty had been stipulated. So that ends my topic, and everyone keep safe, and I'll see you in class. Thank you.